All right, let's get started.
All ready.
Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 1892 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1892, to amend Title IV United States Code to provide for the flying of the flag at half-staff in the event of the death of a first responder in the line of duty.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. On June 14, 1777, the Continental Congress passed an act establishing an official flag for our new nation. The resolution stated that the flag would be 13 stripes, alternate red and white, and that the Union be 13 stars, white in a blue field, representing a new constellation. Since that time, the flag has evolved. Changes were made to its design, shape, and arrangement, with new stars added to reflect the admission of each new state. What has remained steadfast, however, is what the flag represents. It represents one nation, it represents freedom, it represents justice, and it represents the sacrifices made in pursuit of our common values. Federal law provides guidance in displaying and handling the flag so that it is afforded the respect it deserves. Abiding by these guidelines is a way to symbolize the value and love we all hold for what it represents. That is why it is not only appropriate, but necessary for the flag's code's guidelines to include the provision proposed in H.R. 1892, the Hometown Heroes Act. This bill amends the flag code to permit governors and the mayor of Washington, D.C. to order that the flag be flown at half-staff in the event that a public safety officer dies in the line of duty. These public safety officers include local police officers, firefighters, and EMS professionals, a class of individuals who make great sacrifices so we all can live in a free country. These officers work long hours, consistently experience traumatizing incidents, and place themselves in harm's way so we can live the way we do. These sacrifices often go unappreciated. When an officer dies in the line of duty, they are making the ultimate sacrifice for their community, their family, and for their country. This bill allows the American people to show their appreciation to these men and women who are truly the bulwark between order and chaos. They are people who represent the values the founders held so dear so many years ago. Their sacrifice must be recognized and publicly acknowledged, so it is not taken for granted. I urge my colleagues to support this legislation, and it's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, H.R. 1892, honoring Hometown Heroes Act, will bestow one of the highest honors that can be given to our first responders who've died in the line of duty by having the United States flag lowered in their respective jurisdictions. The bill amends the U.S. flag code to allow governors of a state, territory, or possession of the United States and the mayor of the District of Columbia to order that the flag be lowered to half-staff if a first responder from the jurisdiction dies while serving in the line of duty. Our first responders put their lives on the line daily for the greater good of those whom they have taken an oath to serve and protect. Unfortunately, some first responders make the ultimate sacrifice and die while in the line of duty, serving and protecting their communities. Currently, under the United States Flag Code, a governor of a state, territory, or possession of the United States and the mayor of the District of Columbia can order that the flag be lowered to half-staff after the death of a present or former government official or after the death of a member of the armed forces from that jurisdiction. It is only fitting that given the daily sacrifices made by first responders that we honor these brave men and women in the same way as we honor government officials and members of the armed forces when they make the ultimate sacrifice by authorizing governors, and the mayor of the District of Columbia to order that our flag be lowered to half-staff. And so for these reasons, I urge my colleagues to support this important bill, and I thank the chairman.
Chair thanks the gentleman. Are there any amendments to H.R. 1892? A reporting quorum being present, the question is on the motion to report the bill H.R. 1892 favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 1761 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1761, to amend Title 18 United States Code to criminalize the knowing consent of the visual depiction or live transmission of a minor engaged in sexually explicit conduct and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. H.R. 1761, the Protecting Against Child Exploitation Act of 2017, fixes a regrettable, judicially created loophole in the federal production of child pornography statute. In U.S. versus Palomino Coronado, the Fourth Circuit Court of Appeals reversed the defendant's conviction for production of child pornography, citing insufficient evidence. Under the facts of the case, the defendant had engaged in sexual activity with a 7-year-old child and had taken a picture of himself doing so. However, the Fourth Circuit held that a defendant must initiate sexually illicit conduct with the specific intent to create child pornography. In Palomino's case, the court determined that the single photo is not evidence that Palomino Coronado engaged in sexual activity with the child to take the picture, only that he engaged in sexual activity with the child and took a picture. Needless to say, this decision has extremely undesirable consequences in the prosecution of the production of child pornography. It has created a new defense whereby a defendant can merely deny a preformed specific intent to record a sexual offense of a minor and escape federal conviction. That is untenable and clearly contrary to Congress's intent. The creation of child pornography must be adequately deterred to protect children like the 7-year-old Palomino victim. This judicially created hurdle protects her abuser. I thank Mr. Johnson for introducing this legislation to ensure that sexual predators cannot avoid responsibility for their heinous acts against children, and I urge my colleagues to support this important bill. And it's now my pleasure to recognize the ranking member of the Judiciary Committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, H.R. 1761, Protecting Against Child Exploitation Act, would restructure one section of Title 18 of the United States Code as apparently requested by the unit at the Justice Department that enforces the law against child pornography. The bill is intended to address shortcomings in Section 2251 that the department has identified in the statute based on its experience implementing the law. The bill would separate the current provision concerning the production of child pornography into 5 enumerated offenses. Section 2251A prohibits the use of a child to produce child pornography and related conduct, including overseas production and advertising child pornography. 2 new offenses would be added to this section to prohibit the production of child pornography and the transmission of live depictions of a child engaged in sexually explicit conduct, such as live streaming abuse online. This bill would modify the offense of having a minor assist in sexually explicit conduct for the purpose of producing or transmitting child pornography, to prohibit having a minor assist in sexually explicit conduct that violates each of the 3 newly enumerated production offenses except transportation of minor for use in child pornography production. The prohibition against the production of child pornography abroad would be amended to forbid the live transmission of child pornography produced abroad. The jurisdictional requirement for each of the offenses enumerated in Section 2251, except the production of child pornography abroad, would be codified in a separate subsection. Other portions of the bill would be modified to follow the new structure of the statute for consistency. Unfortunately, current law provides a series of mandatory minimum terms of imprisonment for production of child pornography offenses. First-time offenses are punishable by mandatory imprisonment of at least 15 years. Offenders with a prior conviction face mandatory imprisonment for at least 25 years. And offenders with 2 or more prior convictions must be sentenced to imprisonment of at least 35 years. By modifying and expanding Section 2251 to include several new ways in which to violate the prohibition against the production of child pornography, it would subject new classes of defendants to mandatory minimum sentences. To avoid this result, I will offer an amendment to strike the mandatory minimums in current law applicable to this section, but retain the very high maximum penalties so that judges may still, nevertheless, impose even the most severe sentences when appropriate according to each case. And I look forward to the consideration of my amendment and further discussion of the bill. And I yield back and thank the chair.
Chair thanks the gentleman and recognizes the sponsor of the bill, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. I'm honored today to speak in support of my legislation, the Protecting Against Child Exploitation Act, which aims to close a court-created loophole, as we've heard, that exists in our law, and as the title suggests, further protect our children from predators. When I first arrived at Congress after almost 20 years of litigating constitutional law cases, I was deeply concerned to learn that this loophole even existed in current federal law, essentially allowing a predator to admit to sexually abusing a child and yet still evade punishment. In the 2015 case of U.S. versus Palomino Coronado that we've just heard of, the Fourth Circuit reversed the conviction of a child sex offender simply because the court determined the perpetrator lacked specific intent to take the disgusting images of the rape that were found on his smartphone. This is despite the fact that the defendant admitted to sexually abusing the 7-year-old child and memorializing the conduct. In its opinion, the court decided that the lack of, quote, purpose or specific intent was enough to overturn the conviction, even though the defendant himself took the picture of the heinous act and subsequently admitted to sexually abusing the child. This is absolutely a clear contradiction of Congress's intention to protect children. In Scripture, Romans 13 refers to the governing authorities as God's servants, agents of wrath, to bring punishment on the wrongdoer. This committee is an important part of the governing authority of this great nation, and I, for one, believe we have a moral obligation, as any just government should, to defend the defenseless. My legislation presents a simple fix and updates Title 18 of the U.S. Code to ensure future defendants are not able to circumvent the law by simply claiming a lack of intent, especially after knowingly creating a visual depiction of a minor engaged in sexually explicit conduct. More specifically, my legislation amends Section 2251 of Title 18 to prohibit the production and transmission of a visual depiction of a real minor engaged in sexually explicit conduct. Furthermore, it also amends current law to include prohibiting the depiction of a minor assisting any person in engaging in a sexually explicit act. I encourage all my colleagues to support this critical fix so we can close this shameful loophole that now exists in the law. Those that prey on innocent children deserve nothing but the fullest force of our law, and I'm confident this legislation will ensure justice is served. I'm grateful to have the vocal support of our law enforcement community on this bill, including the National Fraternal Order of Police, the National District Attorneys Association, and the Major County Sheriffs of America. Again, I thank the committee for its consideration of this important legislation. With that, Mr. Chairman, I yield back, but note that I do have an amendment at the desk.
Chair thanks the gentleman. Notes that the ranking member of the subcommittee is not present. For purposes of the gentleman from New York, seek recognition.
Strike last word, sir.
Gentleman is recognized for 5 minutes.
Thank you. Although I laud the purpose of the bill and it's a loophole that ought to be closed, the bill has two major problems. Number one, as the ranking member of the committee said, gentleman from Michigan, it subjects to mandatory minimum sentences of 15 to 30 years in prison. For reasons we've stated over and over again, I don't want to go through the debate again now. A number of us, certainly I am very much opposed to mandatory minimums, especially when the mandatory minimum is 15 to 30 years. There may very well be circumstances in which a violator of the statute ought to be sentenced to jail, but not necessarily to 15 to 30 years. We sentence murderers to 25 to life, or even 15 to life. 15 to 30 is way out of line. And second of all, it does not have an exception for situations, the so-called Romeo and Juliet exception. It's one thing when someone is deliberately creating child pornography for the purpose of dissemination or whatever. It's another thing when you have two people who are infatuated or in love with each other, who are close in age, let's say a 19-year-old and a 17-year-old, and they have an affair, and they photograph it and email it to themselves or to somebody, to some friend to show or whatever. It's stupid and infantile behavior, but not deserving of a 15 to 30-year sentence. I don't even think if you're 18 and you're having sex with a 17-year-old and you're photographing it, that's really should be called creating child pornography, so that the 18-year-old is sentenced to a 15-year term and the 17-year-old is a victim when they're having a consensual sex. Certainly if I were their parent or their advisor in some sense, I would advise them not to do that, obviously. But nonetheless, it should not be punished harshly and the life of one of them ruined. So in the absence of an exception for that type of situation where people close in age are having sex with each other and then photographing it, which is stupid, but not venal and criminal, and because of the harsh mandatory minimum sentences, this bill should not be supported unless it is amended to deal with these two problems. I yield back.
Would the gentleman yield?
Yes, certainly.
I thank the gentleman for yielding. I just want to make a point. Your complaints go to the underlying statute and not to the gentleman from Louisiana's bill, which is to correct what I think is a very flawed interpretation of the statute.
Reclaiming my time, it is true. Reclaiming my time, it is true the complaints go to the underlying statute, but by correcting this, and as I said, it ought to be corrected without, but the underlying statute ought to be corrected. By not correcting the underlying statute's two problems, and you are expanding the reach of the statute in a case where, in many cases, someone who does that should not get off scot-free, despite what the court said. But you're creating by undoing this court decision and undoing this loophole, you are creating situations where you will have very unfair and very unjust results because of the two problems I enunciated.
Would the gentleman
so
yield
let me
on that
just
point?
finish. I will in a second. So without correcting those two things, we should not expand the reach of the statute. If we corrected those two things, then this would be in order, and I'll yield.
I thank the gentleman for yielding. The only further point I wanted to make was that I'm not aware, and perhaps the gentleman is aware, but I'm not aware of any complaints about abuse by federal prosecutors under the statute of the matters that you've complained of. I'm not aware of any Romeo-Juliet situations where individuals have been given undue sentences for the type of relationship you described.
Reclaiming my time, I can't cite any. I didn't come here equipped to cite any. I've read about some situations over the years in the newspapers. I can't cite any of them right now. But you should not have a statute hanging around like a loaded bomb for some insensitive prosecutor. And one cannot guarantee that every prosecutor in the United States is intelligent and sensitive. Most are, but there are those who aren't, and we should correct statutory errors instead of expanding them.
Chair, thanks, gentlemen.
Yield back.
For what purpose does the gentleman from Louisiana seek recognition?
Mr. Chairman, I do have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 1761 offered by Mr. Johnson of Louisiana. Page 5,
Without
line
objection, the
7.
amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. The purpose of this bill is to capture child predators who knowingly memorialize the sexual abuse of children. Of course, whether it's to keep these recordings for their own collection or whether it's for distribution, the mere production is repulsive. The bill aims to close a loophole to bar a meritless defense. This amendment to H.R. 1769 is to clarify potential circumstances of misinterpretation of the statute and to ensure that the statute is not used erroneously to prosecute internet service providers when they have not engaged in wrongdoing. The amendment therefore emphasizes that to be criminally liable under subsection A3 of the statute, an internet service provider must have actual knowledge that child pornography is on its server and that it must intentionally transmit the image or intentionally cause its transmission. Internet service providers are in a unique position as common carriers who transmit millions of bytes of data per day. Thus, the standard of knowing transmission for an internet service provider may cause confusion in the courts that would not otherwise arise when an individual knowingly transmits these depictions. The amendment expressly eliminates criminal and civil liability for internet service providers who send child pornography to law enforcement in response to a legal process, such as a search warrant in child exploitation cases. Of course, we would never anticipate a prosecution of an ISP for merely responding to a legal process. However, it's my hope that expressly providing for this immunity in the statute will further enhance the relationship between internet service providers and law enforcement so that they can further facilitate their working together to combat these predators. Mr. Chairman, I encourage my colleagues to support this amendment, and with that, I yield back.
Chair, thanks, gentlemen. For
Mr.
what purpose, the
Chairman.
gentleman from Michigan seek recognition.
I rise in support of the amendment.
The gentleman's recognized for 5 minutes.
Thank you. Members of the committee, I support this amendment because it makes clear that electronic service providers and remote computing services will not be liable under the statute unless they've transmitted certain images intentionally with actual knowledge of the nature of the images. In addition, it clarifies that such electronic services would not be liable for transmitting such images to law enforcement as part of an investigation. These clarifications are consistent with long-standing policy to hold criminals accountable, but not chill the honest operation of electronic services and an open internet. Please support the amendment, and I yield back.
Chair, thanks, gentlemen, for his comments. Question is on the amendment offered by the gentleman from Louisiana. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the amendment is agreed to.
Mr. Chairman,
For what purpose does the gentlewoman from Texas seek
I
recognition?
have an amendment at the desk, 092. I have two amendments at the desk,
The clerk will report which amendment.
092. I'd like to do them back to back. 092.
Let me ask the ranking member, did you? Is that,
That's
okay,
all
we'll-
right.
Now,
we'll go ahead and do
they're
that.
not on block, but they're,
No, we understand.
All right,
He has
thank
an amendment too, but I'm happy to have the gentlewoman's
Thank you,
amendments
Mr.
considered in order.
Ranking Member.
And we'll start with 092. Clerk will report the amendment.
Amendment to H.R. 1761 offered by Ms. Jackson Lee of Texas. Page 5, line 7, insert after United States the following.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
I thank my colleagues on both sides of the aisles. I thank the chairman and the ranking member. And I want to state for the record that I abhor sexual predators and understand the basis of this important legislation as I have supported it from the time I've been a member of this Judiciary Committee. But I note the importance of this particular amendment that deals with the Romeo and Juliet exception. This is not a mandatory minimum. It is an exception to the mandatory minimum. and it indicates the need to be able to be responsive to teenagers. The bill in front of us would expand and modify the meaning of sexual exploitation under Section 2251, thereby having a sweeping effect and adding additional offenses to an already very inclusive criminal code and resulting impact on the criminal justice system generally, and may involve mass incarceration. My primary concern with this bill is the cumulative effect it will have on our young people, our youth. Given the change of times and how youth communicate with each other, we must proceed with caution and due care when implementing legislation that will have a lifetime adverse impact on this special segment of our population. They are the future of America. We must take care to ensure that the legislation does not usurp their opportunity to thrive, go to college, be positioned to carry on good work we are all doing today. We were all juveniles at some point and may recall some of the innocuous behaviors we engaged in that our parents policed to make sure we got back in line. This bill takes that role out of the hands of parents, community organizations, and other support groups and places it in the hands of the law, which under this bill is harsh in its sentencing and unforgiving of mistakes made as juveniles. Teenagers are immature risk takers who do not fully comprehend the consequence of their actions, and science has confirmed this and illustrates that the frontal lobe is not fully developed until the age of 24. That's why it is best to address these matters in juvenile court, which can provide remedies that convey to juveniles that the seriousness of their actions while avoiding the stigma of criminal conviction and a lifetime of registration as a sex offender. Take Jacob C., for example, who at 11 years old was tried and found guilty of one count of criminal sexual conduct. He was placed on Michigan's sex offender registry and prevented by residency restriction laws from living near other children. When he was 14 and unable to return home because of his restriction, he became the foster child of a pastor and his wife, who both helped little Jacob deal with the trauma of growing up on the registry. Mr. Chairman, I'd like to submit this article for the record, which depicts the irreparable harm. In discussing the production and transmittal of live and visual depiction of minor engaged in any sexual explicit conduct, we must give an extra weight to the innocence portrayed.
Without objection, the document will be made a part of the record.
Thank you. Portrayed when juveniles engage in texting each other casually and where no coercion has involved. For example, two teenage girls, 12 or 13, are hanging out, taking photographs of each other on their cell phones, where one of the girls is photographed talking and the other is flashing a peace sign. Like many teenagers, they are depicted in their sports bra in the photo and think nothing of it. My amendment, of course, wants to accept persons on 19 years or under at the time of the violation be punished for a violation of this section by imprisonment for not more than 1 year or a fine under this title, or both, if no coercion has occurred, and that the violation consists solely of producing or causing to produce a visual depiction. In showing their friends the silly photos, the photo was confiscated by the teacher, who then called the parents into the school because the girls were then facing child pornography charges. The innocent charges were labeled as provocative and semi-nude by the DA. And so I would ask my colleagues to support the Jackson-Lee Amendment, which is a reasonable response to the importance of training children, teaching children, and not criminalizing children. I ask my colleagues to support the Jackson-Lee Amendment. With that, I yield back.
For what purpose, the gentleman from Louisiana seek recognition.
Mr. Chairman, I oppose the amendment.
Gentleman is recognized for 5 minutes.
It's true, as has been conceded this morning, the objections do concern the underlying statute regarding minimum mandatory sentences, and my legislation doesn't create any new mandatory minimum sentences. Instead, it modifies existing statutory framework to ensure the existing enhancements are applied equitably and to close this loophole that we've all discussed. It's simple. My legislation prohibits the production and transmission of a visual depiction of a real minor engaged in sexually explicit conduct. Nothing in this legislation adds to mandatory minimum sentencing at all. The primary responsibility of this committee is to address the problems of the day and protect the public, especially our children. Sex crimes against children are ubiquitous. Their number, as we've heard in our child protection hearing last month, is growing. Additionally, the offenses are becoming more depraved and the victims are getting younger. There's no sign of this crisis slowing down, and the present law does not appear to be keeping up with the numbers. The gravity and growing prevalence of these crimes merit an appropriate societal response to have a proper deterrent effect. The enhancements here will create a further deterrent effect. Unfortunately, I believe that this amendment will not fix a federal problem. Instead, its risks outweigh its benefits. It will create another loophole and allow numerous predators to escape prosecution. Juveniles are typically not prosecuted federally unless there is no recourse at the state level. Federal prosecutions in that regard are rare. This amendment would create a loophole that we're trying to avoid. would essentially allow young sex traffickers, for example, to escape prosecution because they're closer in age to their victim. We know that sex trafficking is increasingly used by young gang members, for example. They traffic women in their teens and they force them to sell themselves. So I believe that this amendment, while I know it's well-intended, is not appropriate. It will actually create more risk than it resolves, and I oppose it for that purpose. I encourage my colleagues to do the same. I yield back.
Mr. Chairman,
What purpose does the gentleman from Michigan seek recognition?
I rise in support of this amendment.
Gentleman is recognized for 5 minutes.
Members of the committee, the amendment is intended to provide an opportunity to avoid mandatory minimum sentences in certain cases involving sexting by teenagers. The amendment would allow for the imposition of misdemeanor penalties in such cases where the defendant is no more than 19 years old and no more than 4 years older than the victim. The victim must have been a willing participant in producing or transmitting a sexually explicit photo or video. Now, the pervasiveness of personal devices such as cell phones and tablets have given rise to teenage sexting, the use of these devices to send and receive sexually explicit messages or images. Research has shown that teenage sexting is widespread even among middle schoolers, and a study conducted by Drexel University found that more than half of the undergraduate students who took part in an online survey said that they sexted when they were teenagers. 30% said they included photos in their messages, and surprisingly, 61% did not know that sending nude photos via text could be considered child pornography. Another online survey found that almost 40% of teenagers between ages 13 and 19 had sent sex message. Almost 50% had received a sex message, and 20% posted nude or semi-nude content line. Under the bill, teenagers prosecuted for sexting would be subject to mandatory prison sentences of at least 15 years under Section 2251. And so this amendment takes teen sexting out of the realm of child pornography, providing an alternative to harsh mandatory sentences. I think this is a reasonable amendment, and I urge its support.
Would the gentleman yield?
Of course, with pleasure.
I thank the gentleman for a more than detailed support of the amendment. I thank him for his explanation. And I want to bring to, because you were so right, teenage sexting, which is, because of technology, a phenomenon of today, the 21st century. And to the offer of this legislation, the amendment or present legislation amends the underlying bill. And so this amendment is both relevant and needs to deal with that subject of what happens to juveniles now. And I just want to draw the attention to Jacob, who unfortunately that he had to register, but fortunately he was able to find 2 individuals who helped restore his life. But yet he was still registered at the young age of 11. And I believe that this is a fair amendment that addresses that question, protects society, as the underlying bill wants to do and as I have supported, but recognizes that children are children in this instance. And I can't imagine why my colleagues would not be supportive of this legislation. Again, I ask my colleagues to support the Jackson Lee Amendment. Thank you.
Thanks for your comments, and I yield back, Mr. Chairman.
Chair thanks. Gentleman recognizes himself in opposition to the amendment. While I appreciate Ms. Jackson Lee's sentiment in introducing this amendment, it is unnecessary and I must oppose it. Prosecutorial discretion has been a sufficient buffer in assuring this statute is properly applied. Again, I've heard no complaints that this provision has been used to prosecute so-called Romeo and Juliet cases at the federal level. In fact, nowhere in the chapter has such an exception, and I've heard no allegations of abuse in federal prosecutions under the offenses in this chapter, such as distribution or possession of child pornography. This amendment is not fixing a problem. Instead, it creates a loophole whereby an offender may escape criminal prosecution based on his age, even if he is unquestionably guilty of the crime. This amendment would exclude an arbitrary swath of individuals who may be committing horrific crimes against children in producing pornography. And let me point out, in the case at hand, this was a horrific crime, and we're trying to fix the statute to cover that type of situation. I don't see a need to change the statute for this purpose. Prosecutorial discretion has worked, and that's why this amendment is unnecessary. The point of this legislation is to close loopholes, not to create new ones, and I urge my colleagues to reject the amendment. First, the gentleman from Tennessee, seek recognition.
Word.
Gentleman's recognized for 5 minutes.
I'm going to support the amendment and all the amendments and probably the bill. But I would hope that in circumstances like this, that instead of having to do so, that we could try to work out amendments that make sense. Now, I don't understand particularly Romeo and Juliet defense. Romeo would have had to have a pen and paper and be drawing. And it may be an indication of my age, but I always understood that sex was a lot like driving. You should use both hands, and not necessarily one for the camera. But if one chooses to do such, I guess they could. But it does seem we could come up with an amendment that would satisfy the quote-unquote Romeo and Juliet defense and not leave it to prosecutorial discretion. We shouldn't be passing laws that we recognize have a possible space in them that needs closing and leave it up to the discretion of the prosecutor, because you could have a bad prosecutor, and I think we could draw a proper amendment. We had this last week when we had a bill up, and I think it was one of the gentlemen from Texas, maybe Mr. Gomer, or no, it was Mr. Poe, and he said something about making folks second-class sheriffs, law enforcement second-class citizens, and I suggested it was making governors and states second-class political entities and office holders, and that was part of the underlying statute. Well, we could fix the underlying statute at the same time we're fixing the punishment. And it just seems like this committee could be doing a whole lot more good than just passing laws that, like Mr. Johnson's, that are good in terms of catching a loophole, but at the same time, if we see another problem with the main offense, that we don't clean it up when we have a chance to do it. And I think we do a better service to our code, to our country, by cleaning up potential prosecutorial saves by finishing it with Max Scherzer going 9 and not depending on the bullpen to save us. I yield back the balance of my time.
Question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye. Aye. Those opposed, no. The opinion of the chair, the noes have it. Roll call is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Liu votes yes. Mr. Raskin? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Schneider? Mr. Schneider votes yes.
The gentleman from Arizona.
Mr. Franks votes no.
Gentleman from California.
Mr. Issa votes no.
The gentleman from California.
Mr. Swalwell votes no.
The gentleman from Texas.
Mr. Poe votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 11 members voted aye, 18 members voted no.
And the amendment is not agreed to.
I have an amendment at the desk.
Mr.
I think we said we'd let her do both for a minute. The clerk will report the Jackson Lee amendment.
Amendment to H.R. 1761 offered by Ms. Jackson Lee of Texas. Page 5, line 7.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on her amendment.
I thank you. Ladies and gentlemen, this is dealing with the registration. I'll make it very simple, is that these individuals of this age, teenagers, who, pursuant to my earlier amendment, I believe the matter should be handled in a juvenile setting with parents, family members, society, teaching juveniles who are like the two girls or like Jacob, 11 years old, and that they should not have to be registered, that this does no harm to the underlying legislation or the legislation, and as well, it deals with it not being violent, not being coercive, and we really have a problem if we are going to subject our juveniles to this kind of treatment and then having to be registered, and then, of course, they will be subject to mandatory minimums and an irreparable harm of a sex offender registration program. That means it carries them through summer jobs, it carries them through college, it carries them through their life. I ask my colleagues to support the Jackson Lee amendment. I yield back.
Mr. Chairman,
For what purpose does the gentleman from Louisiana seek recognition?
Mr. Chairman, I oppose the amendment, but
Gentleman is
first,
recognized for 5 minutes.
thank you. First question, whether it's germane or not. This deals with the Adam Walsh Child Protection and Safety Act of 2006, which is not directly
If the
addressed.
gentleman would yield,
Will.
we have determined that it is germane, and you can proceed to the substance of the amendment.
Thank you, Mr. Chairman. Well, I would oppose the amendment on substance for the same reasons that I opposed the last amendment. There's no similar carve-outs that exist in related statutes. The Department of Justice says that these types of changes are unnecessary and they would potentially exacerbate the problem, causing further loopholes. And as has been stated eloquently by the chairman, I do not believe America's prosecutors are engaging in any widespread abuse of these statutes. There's no evidence of that. Prosecutorial discretion is part of our system. We rely upon it, and I think it's sufficient here. And for that reason, and many of the others that have been stated already, I would oppose this amendment and encourage my colleagues to do the same, and I'd yield.
Chair thanks gentlemen. For purposes, gentleman from Michigan seek recognition.
I rise in support of the amendment,
Gentleman is recognized for 5 minutes.
and I'd yield briefly to the gentlelady from Texas.
I thank the gentleman very much, and so this is just a passionate plea on behalf of young people who make mistakes, teenagers under 19, 11-year-old, 13-year-olds. Prosecutorial discretion is not the answer. We're writing a bill that is labeling teens as sex offenders, non-coercive acts, texting, sexting, and I can't imagine that there is not a clarity of mind. I think my colleague from Tennessee was correct. There's no reason why we couldn't have crafted the legislation better, the underlying legislation, and of Mr. Johnson's, and why Mr. Johnson is not willing to see the reasonableness of these amendments, and that we could have an opportunity to work through them. That did not occur. But I am insistent on the fact that this is wrong-headed and does nothing but an injustice to our young people. They do not deserve, under circumstances of playful sexting, wrong behavior, to be labeled as a lifetime sex offender. I'd like to get their lives corrected. I'd like to get them in treatment. I'd like to have them understand what their options are. But with that in mind, I ask my colleagues to support the legislation that simply asks that these kids not be on a permanent lifetime sex offender registration list. With that, I yield back to the gentleman. I thank him for his kindness.
My colleagues, I am impressed by the compassion that is the basis of the gentlelady's remarks. It's important to me that an amendment that would exempt teenagers from federal sex offender registration requirements who are involved in sexting and convicted of a misdemeanor, that would be more appropriate. But a conviction that requires a teenager to register as a sex offender can inflict lifelong consequences that affect the ability to work or obtain an education, and maybe even limit where that teenager may live. And so the Jackson-Lee Amendment would allow teenagers to avoid the stigma of being labeled as sex offenders for non-malicious conduct that is not indicative of future criminality. And so I urge my colleagues here to support the compassion that surrounds this amendment and urge its support. And I thank the chairman.
Chair thanks the gentleman and recognizes himself in opposition to the amendment. The amendment would insert a provision into federal law to clarify that provisions of H.R. 1761, which are intended to protect children from sexual predators, do not apply to so-called Romeo and Juliet cases, meaning cases involving a child above the age of 15, where there is not more than a 4-year age difference between victim and perpetrator. I appreciate the sentiment behind this amendment. However, this amendment is misguided for 2 reasons. First, current law already specifically excludes, in appropriate circumstances, these so-called Romeo and Juliet cases from the definition of sex offense. Second, as I stated earlier, this amendment seeks to fix a problem that does not exist. This bill is intended to protect children from sexual predators. I'm not aware of any so-called abuses of this statute by federal prosecutors. Finally, I would remind my colleagues that this legislation does not, as many of them have stated, expand the reach of the statute. What it does is fix a regrettable and misguided Fourth Circuit Court of Appeals decision that inserted a loophole into federal law which protects the perpetrator, not the child, and was clearly contrary to congressional intent. For that reason, I urge my colleagues to oppose the amendment.
Gentleman yield?
I'd be happy to yield to the gentleman.
Yeah, I'm just curious as to what the gentleman is referring. I am told that, I'm not aware of a Romeo and Juliet exception to Section 2251, certainly not for the older of the two.
I'm referring to a provision in Section 16911, 42 U.S.C. 16911, dealing with the Adam Walsh, right, and which the gentleman's amendment seeks to amend. In the
And that would
provision-
apply here?
Yeah, subsection C, offenses involving consensual sexual conduct.
And without the gentlelady's amendment, that would apply in a situation like this?
It would apply in many situations like this. It would,
In many, but not all? I mean, where's
it
the
would
difference?
depend on the facts of the case, what constitutes a, quote, Romeo and Juliet relationship.
Well, a 19 and a 15-year-old, an 18 and a 17-year-old, that's what we're talking about.
The section says an offense involving consensual sexual conduct is not a sex offense for the purposes of this subchapter if the victim was an adult, unless the adult was
If the victim was an adult?
under the custodial authority of the offender at the time of the offense, or if the victim was at least 13 years old and the offender was not more than 4 years older than the victim. Question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the noes have it. Roll call is requested. Clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Isa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal? Mr. Schneider? Mr. Schneider votes no.
The gentleman from Arizona.
Mr. Franks votes no.
The gentleman from Texas, Mr. Poe. The
Mr.
gentleman from
Poe
Texas,
votes no.
Mr. Gomert.
Mr. Gomert votes no.
Has every member voted who wishes to vote? The clerk will report.
No. Mr. Chairman, 9 members voted aye, 18 members voted no.
And the amendment is not agreed to. For purposes, the gentleman from Michigan seek recognition.
I have an amendment at the desk, Mr. Chairman.
Clerk will report the amendment.
Amendment to H.R. 1761 offered by Mr. Conyers. Page 4, insert after
Without
line
objection,
5.
the amendment is considered as read, and the gentleman is recognized on his amendment.
Mr. Chairman and my colleagues, this amendment addresses the issue of the mandatory minimum sentences that unfortunately is raised by our consideration of the bill. The bill in front of us would make a number of changes to the federal statute prohibiting the sexual exploitation of children through the production of child pornography. Certainly, we should do all we can to prevent this crime and to assist victims and hold offenders accountable when these crimes do unfortunately take place. Accordingly, the current statute would allow for quite lengthy maximum sentences for such crimes. I do not oppose lengthy statutory maximum penalties for such egregious cases. However, for every level of the offenses in this section of the code, from the first-time offenders to recidivist offenders, there are also mandatory minimum penalties in current law. And that's what the point of this amendment is. I believe we must start the process of eliminating mandatory minimum sentences. We must get rid of them. Even with regard to statutes involving such egregious conduct, we should not set minimum penalties that preclude judges from determining which sentence level is appropriate. Judges are obviously aware of the facts and circumstances in each case and are in a better position to set sentences. And therefore, I offer this amendment to current law to retain the high maximum penalties for the offenses amended by this bill, but eliminate the unnecessary and unwise mandatory minimums. Offenders may still receive sentences greater than the current minimums, all the way up to the quite lengthy maximum penalties, but those would be imposed on a case-by-case basis by the judge, which is how it should be. And so I plead with my colleagues to receive this amendment in a favorable manner and support the amendment, and I thank the chairman.
First gentleman from Louisiana, seek recognition.
Thank you, Mr. Chairman. Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you. I rise to oppose the amendment and not to sound like a broken record, but we've discussed this now over and over with regard to all of these. This is not the time or the place to deal with the underlying statute regarding mandatory minimum sentences. This bill doesn't directly address that. It's simply trying to close a loophole, as we said. And for that simple reason, I oppose this amendment and encourage my colleagues to do the same. I yield back.
The chair recognizes himself in opposition to the amendment. This amendment goes outside the scope of this bill and seeks to repeal established minimum sentences that already exist in current law and that apply to offenders who produce child pornography. We have just spent the last several minutes discussing the horrors faced by children subjected to unspeakable abuse at the hands of these predators. This legislation does not amend current penalties under the law, but rather simply closes a loophole that allows child predators to escape liability for their heinous crimes against our children. I cannot in good conscience support this amendment, which would proactively reduce the current law punishment for these crimes. Every time an image of child pornography is viewed, the victim is re-victimized. Victims spend the rest of their lives wondering who is looking at their abuse, or worse yet, experiencing gratification from it. It is important that there is no confusion that the very creation of these images is abhorrent. regardless of whether or not the abuse was done with the specific intent of creating an image or if the intent to memorialize this conduct was a secondary thought. Consider the facts of the case that led to this bill. An adult male had sexual relations with a 7-year-old and felt the need to photograph it. That is the production of child pornography. No one should be permitted to escape responsibility merely by asserting they did not have the specific intent to create the image when they were abusing the child. The act of taking a photo or making a video should be enough to demonstrate intent, and I urge my colleagues to oppose this amendment. Question occurs on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. Being the chair, the noes have it. The amendment is not agreed to.
Record vote is
Record vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes no. Mr. Shabbat? Mr. Isa? Mr. King? Mr. King votes no. Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes no. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes no. Mr. Gowdy? Mr. Gowdy votes no. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Arizona, Mr. Franks.
Mr. Franks votes no.
Gentleman from Texas, Mr. Poe.
Mr. Poe votes no.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes no.
Gentleman from Iowa, Mr. King.
Mr. King votes no.
Gentleman from Arizona, Mr. Biggs.
Mr. Biggs votes no.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 9 members voted aye, 17 members voted no.
Mr. Chairman,
And the amendment is not agreed to. For what purpose does the gentlewoman from California seek recognition?
to strike the last word.
Gentlewoman is recognized for 5 minutes.
I am disappointed that some of these excellent amendments that would have made the statute better have not been accepted. Nevertheless, I do believe that it is necessary to correct the problem created by the court decision. And so, despite my disappointment at the losing amendments, I intend to support the overall bill. And I wanted to thank also the committee for working together to resolve the internet issue so that there would be an unintended consequence of the bill. And I would also like to yield to my colleague, Mr. Nadler.
I thank the gentlelady for yielding. I just have 2 comments. Number one, because of the failure of these amendments on the Romeo and Juliet exception and the mandatory minimums, I plan to vote against the bill. But the reason I sought recognition now is that I am advised, going back to Ms. Jackson Lee's amendment, I am advised by staff that the section of the law read by the chairman applies to the crime to the sexual crime. It does not apply to the child pornography crime. And that being the case, I would hope that before this bill comes to the floor, if it is reported from committee, we could look at that again and apply the same exception to the child pornography section that the law already applies to the underlying sex exception. It was apparently the impression of the committee leadership that already did that, but since it doesn't do that, I would hope we could take another look at that before it comes to the floor. I thank you. I yield back.
And I yield back.
Are there further amendments to H.R. 1761? A reporting quorum being present, the question is on the motion to report the bill H.R. 1761 as amended favorably to the House. Those in favor respond by saying aye.
Aye.
Aye. Those opposed, no. No. The ayes have it, and the bill as amended is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. You want to do this first, 22? The bill's been reported. It's too late to do that. Pursuant to notice, I now call up H.R. 2266 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2266, to amend Title 28 of the United States Code to authorize the appointment of additional bankruptcy judges and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. A well-functioning bankruptcy system is an essential element of our economy, providing relief to consumers and allowing businesses to reorganize, preserve jobs, and maximize the value of assets. A strained bankruptcy judiciary will slow that system down and undermine the essential benefits it provides. There are presently 29 temporary bankruptcy judgeships in the bankruptcy system with a lapse date of May 25, 2017. These temporary judgeships comprise more than 8% of the current bankruptcy judgeships nationwide. After May 25th, these judgeships are at risk of being permanently lost, resulting in larger caseloads shared by fewer judges and causing further strain on our judiciary system. The Bankruptcy Judgeship Act of 2017 converts 14 of the existing temporary judgeships to permanent status and creates 4 new permanent bankruptcy judgeships in districts with some of the highest caseloads in the country. In fact, since the enactment of the Bankruptcy Abuse and Prevention and Consumer Protection Act of 2005, when a majority of the temporary judgeships were created, these districts have seen weighted filings increase by more than 55%. This bill is based on a comprehensive study of judicial resource needs conducted by the Judicial Conference and is supported by the Administrative Office of the U.S. Courts. The conference has assured us that its request comes only after it has taken steps to maximize all other alternatives to reduce judicial workloads. Moreover, the conference has demonstrated that while a district may have a permanent judgeship, it will not be filled unless completely necessary. Importantly, this bill will not present any new costs for the taxpayers. The Bankruptcy Judgeship Act includes an increase in the quarterly U.S. trustee fees for large Chapter 11 debtors, excluding small businesses. This fee increase is directly tied to the balance of the United States Trustee System Fund and will only be applied when the balance of the fund falls below a $200 million threshold. These temporary bankruptcy judgeships were first set to lapse in 2010. They have been extended for over 12 years. Despite this committee's previous efforts to address the issue, to date there have been only limited short-term fixes. Additional permanent bankruptcy judgeships have not been authorized since 1992. The time has come for Congress to address bankruptcy judgeship needs more permanently. We need a bankruptcy system that has a sufficient number of judges to be able to manage the system's caseload in a just, economical, and timely manner. This bill ensures that we have such a system. I'd like to thank Ranking Member Conyers for his leadership on this issue, and I'd also like to thank Regulatory Reform, Commercial and Antitrust Law Subcommittee Chairman Marino and Ranking Member Cicilline for joining me as original co-sponsors of the bill, and I urge my colleagues to support this legislation. It's now my pleasure to recognize the Ranking Member, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Every 2 years, the Judicial Conference of the United States undertakes a comprehensive survey of all judicial circuits to determine whether to request additional bankruptcy judgeships and whether any temporary bankruptcy judgeships should be extended. Earlier this week, I introduced H.R. 2266, the Bankruptcy Judgeship Act, together with my chairman, Goodlatte, and Regulatory Reform Chairman Marino, and Ranking Member David Cicilline, based on the results of the conference's most recent request to Congress. I encourage my colleagues to support this legislation for several reasons. To begin with, the measure reflects the conference's request, which itself is based on its highly prudential survey of judicial resource needs. This analysis consists of two components. The first is premised on a case weight formula devised by the Federal Judicial Center, intended to provide a more accurate and useful measure of judicial workload than a mere count of case filings. The second component considers a broad array of other factors, including the nature of a court's caseload, filing trends, demographic considerations, geographic issues, and economic aspects, among other items. Taken together, the resulting analysis provides a reliable basis upon which Congress may assess the necessity of authorizing additional judgeships. In addition, H.R. 2266 addresses an immediate need. All of the temporary judgeships addressed in H.R. 2266, as pointed out by the chairman himself, lapse as of May 25th, which is just 3 weeks away. And once a temporary judgeship lapses, any ensuing vacancies may not be filled. Accordingly, I share the conference's concern that the bankruptcy courts would face a serious and, in many cases, debilitating workload crisis if their temporary judgeships were to expire. This is particularly true with respect to the Eastern District of Michigan, my district, which has a weighted caseload well in excess of the minimum necessary to trigger additional judicial resources. Congress has previously extended temporary bankruptcy judgeships from time to time, but some have also lapsed as a result of Congress's failure to act in a timely fashion. So, to avoid future lapses in judicial resources, my legislation converts these temporary judgeships to permanent status. Finally, I'm pleased to report that H.R. 2266 pays for all of these judgeships without having to require consumer debtors to bear that cost. The cost of this legislation is offset by increasing the quarterly fees that the largest 10% of Chapter 11 debtors pay to the United States Trustee System Fund, a proposal initially made by the Obama administration as part of the president's budget request for 2017. Specifically, The fee increase would apply only to Chapter 11 debtors that have quarterly disbursements in excess of $1 million and only during the period when the fund has less than $200 million. And so in closing, I again express my appreciation to Chairman Goodlatte, Chairman Marino, and Ranking Member Cecilini, as well as their staff, for their cooperative efforts in working with me on this bipartisan legislation. And so I urge my colleagues to join us in supporting the measure and yield back the balance of my time. Thank you.
Chair thanks the gentleman. For what purpose is the gentleman from,
Tennessee.
no, I know, I'm trying to determine, the gentleman from Michigan has an amendment as well, but I don't, I take it, the chair will instead recognize the gentleman from Rhode Island, since I don't think he has an amendment. He wants to speak about the bill. Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. H.R. 2266, the Bankruptcy Judgeship Act of 2017, authorizes the establishment of 4 additional permanent bankruptcy judges and converts 14 temporary bankruptcy judges to permanent status. I'm pleased to be an original co-sponsor of this legislation, which is a necessary response to alleviate the strain on bankruptcy courts in certain districts that have experienced a significant increase in bankruptcy filings over the past decade or more. Importantly, this legislation adopts the recommendations of the Judicial Conference of the United States, the national policy-making body of the federal courts, and does not impose additional fees on ordinary consumer debtors. As the conference notes in support of this measure, while bankruptcy filings have decreased nationwide, the bankruptcy courts that would receive permanent or new judgeships under this legislation have seen weighted filings increase by more than 55%. Furthermore, without this legislation, all 14 temporary judgeships covered by this bill will lapse later this month on May 25th. Allowing a lapse in these judgeships would have potentially crippling effects on the bankruptcy system. For example, 5 of the 6 authorized judgeships of the U.S. Bankruptcy Court of the District of Delaware, the preferred venue for corporate reorganization under Chapter 11, are temporary. Accordingly, I urge the swift adoption of this critical legislation, and I thank Ranking Members Conyers, the bill's sponsor, for their leadership, and Chairman Goodlatte and Subcommittee Chair Marino for their support of H.R. 2266, and yield back the balance of my time.
Chair thanks the gentleman. For what purpose the gentleman from Michigan seek
Mr.
recognition?
Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Mr. Chairman,
For what purpose the gentleman from,
I'd like to speak in support of the main bill.
well, you'll be able to speak at any time during the process in support of the main bill, and I'll recognize you at the appropriate time. But the amendment will be reported by the clerk.
I'll say to my colleague from Georgia that these are merely technical revisions that I'm bringing forth now in this amendment.
Clerk will report the amendment.
Amendment to H.R. 2266 offered by Mr. Conyers of Michigan. Page 2, line 9.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you. Mr. Chairman and members, my amendment makes a series of purely technical revisions to H.R. 2266, some of which were informally suggested by the Executive Office of the United States Trustee. These revisions correct certain typographical errors and specify that notwithstanding an intervening vacancy in an authorized judgeship, the position can nevertheless be filled. In addition, the amendment includes clarifying language concerning the allocation of the United States trustee quarterly fees. And so again, I thank the chairman and appreciate the collaborative efforts that we engaged in the pursuit of this timely legislation and with respect to my amendment. Thank you.
Would the gentleman yield?
Of course.
I thank the gentleman for yielding and strongly support his amendment, and I believe it improves the bill and ensures that these important judgeships are preserved, and we must maintain our well-functioning bankruptcy system. So I thank the gentleman for yielding.
Thank you, sir, and I yield back.
At this time, the chair will turn to the gentleman from Georgia for his remarks, and he's recognized for 5 minutes.
Thank you, Mr. Chairman. I rise in support of...
Let me have a vote on the underlying amendment, unless somebody else wants to address the amendment. The question is on the amendment offered by the gentleman from Michigan. All those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it. The amendment is agreed to. Now we'll go to the gentleman from Georgia for his comments on the underlying bill.
Thank you, Mr. Chairman. I rise in support of the underlying bill. As former chairman of the Courts and Competition Policies Subcommittee of the Judiciary Committee, and also as former ranking member on the Regulatory Reform, Commercial, and Administrative Law Subcommittee, I support this bill, which would authorize 4 additional permanent bankruptcy judgeships and convert 14 temporary bankruptcy judgeships to permanent status based upon the most recent recommendation of the Judicial Conference of the United States. Bankruptcy case filings have increased by more than 55% for the involved districts since the last time additional judgeships were authorized in 2005. In addition, all 14 of the temporary bankruptcy judgeships in the full bill that the bill converts to permanent status lapse as of May 25th of 2017. If this bill is not passed, the remaining permanent bankruptcy judges in the affected districts will face a crippling caseload. I strongly support this bill, Mr. Chairman, and I yield back.
Chair thanks, gentlemen, and now recognize the gentleman from Tennessee for his amendment.
Thank you, sir.
Clerk will report the amendment.
Amendment to H.R. 2266, offered by Mr. Cohen of Tennessee. At the end of the bill, add the following.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Thank you, Mr. Chairman. This amendment would extend a temporary bankruptcy court judgeship in the Western District of Tennessee for 2 years, not make it permanent, but extend it. We had a bill in 2010 that passed this committee when Mr. Coble, I was the ranking member of this appropriate subcommittee, and Mr. Coble was, I was the chair, and Mr. Coble was my ranking member. We passed the bill. It should have passed the Senate in 2010 at the height of the bankruptcy problem, and this temporary judgeship would have been made permanent. It was not agreed to in the Senate because of the small-minded thinking of the senator who was responsible that there would be incidental costs like hiring clerks. And because of that, we didn't get bankruptcy judges that could put people back in a position to participate in society and earn a living. But unfortunately, that happened. Tennessee in the Western District has been one of the highest incidences of bankruptcy in our nation's history. And for that reason, one of my predecessors, Walter Chandler, in the 1930s passed a significant bankruptcy bill that we worked under for years. This court is still needed. I don't believe our division realized that it was coming up and wasn't going to be included, or else it would have reached out to the Sixth Circuit, which could have recommended such and probably had it among the judgeships that were at least extended, if not made permanent. Judge Kennedy did not approach Judge Donald on the Sixth Circuit or anybody else, and so the Sixth Circuit didn't make such a recommendation. We have 5 judges, 4 work basically in Memphis and 1 in Jackson. If we lose this temporary judgeship, it means a judge has to be spending time traveling to Jackson and hearing cases there. That's a waste of time for that judge and an additional expense. Even though incidental and small-minded, it seems to go contemporaneously with the thinking that the Senate had in 2010 and defeated the opportunity to have this judgeship made permanent then. Statewide, Tennessee sees a high bankruptcy relative to its population. From 1990 to 2016, it's 96% above average. Nationwide, as bankruptcy filings have fallen by approximately 50% between 2010 and 2016, filings in Tennessee have only fallen by 29%. There's a strong possibility the caseload the Judicial Conference is working off of for the Western District may not represent the full caseload. The reduced number end up being more of an outlier than a defining trend. This would not create a new bankruptcy court judgeship. It would simply preserve the status quo in terms of staffing until we see the results of the next Judicial Conference survey. I would ask that the committee agree with this amendment, extend this temporary judgeship for 2 years in Western District of Tennessee, which is having terrible economic times, has suffered historically from bankruptcies, and would have had a permanent judgeship but for the errant thinking of the Senate at the time. With that, I'd yield back the balance of my time and would ask for a positive vote.
The chair thanks the gentleman and is concerned but recognizes himself in opposition to the amendment. Let me take you through the process that we've been through and the Judicial Conference has been through. The 14 temporary judgeship conversions and the 4 newly authorized judgeships contained in this bill are based on the Judicial Conference's most recent recommendation from April 3, 2017, and are supported by the Administrative Office of the Courts. The Judicial Conference's recommendation to Congress concerning the need for bankruptcy judgeships is the product of a multi-step process. First, a bankruptcy court submits a request for additional bankruptcy judgeships to the district court, which transmits the request to the circuit court. Then the circuit court's judicial council considers the request and either approves it with or without modification or disapproves it. Approved requests are then sent to the Judicial Conference's Bankruptcy Committee's Subcommittee on Judgeships for consideration. The subcommittee reviews the circuit court's recommendation, conducts on-site evaluations of judicial needs, and makes a recommendation to the full bankruptcy committee. The bankruptcy committee reviews the subcommittee's findings and makes a recommendation to the full judicial conference. Upon final approval, the recommendation is then transmitted by the judicial conference to Congress in its biennial report. The judicial conference did not recommend that the temporary judgeship in Tennessee be converted to permanent status or extended. No one is closer to the needs of the court system than the Judicial Conference and the Administrative Office. I'm not aware of any facts or circumstances that would supersede the well-developed recommendation of the Judicial Conference to not convert or extend this judgeship. So I would just say to the gentleman, I'm concerned because he reports a different experience. However, I think it is not a good precedent for this committee to jump in based upon this one set of facts. So if the gentleman, I can't support the amendment, but if the gentleman would withdraw it, we certainly can go back through the process. And if the conference comes back at any time with a recommendation that the judgeship be extended or be made permanent, I think the committee should then take it up. But at this point in time, it would be my preference to have the gentleman either withdraw the amendment or that the amendment be opposed.
I will accept that offer and withdraw, as I did take math and understand the situation. To some extent, I'm just upset about what the Senate did in 2010. And it was really small-minded thinking. But that thinking existed, and if we can, I'll get Judge Kennedy to ask the Sixth Circuit, and if we can get something better, we'll get it. And thank you, sir.
I thank the gentleman for withdrawing. Without objection, it is withdrawn. Are there any further amendments to H.R. 2266? Being none, a reporting quorum being present, the question is on the motion to report the bill H.R. 2266 as amended favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it, and the bill as amended is ordered reported favorably. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. We have one bill remaining. Pursuant to notice, I now call up H.R. 1039 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1039, to amend Section 3606 of Title 18 United States Code to grant probation officers authority to arrest hostile third parties who obstruct or impede a probation officer in the performance of official duties.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Under current law, a federal probation officer may arrest a probationer or an offender on supervised release if the officer has probable cause to believe that the offender has violated a condition of his or her probation or release. The officer may make the arrest with or without a warrant. Unfortunately, current law does not grant probation officers arrest authority in situations where a third party attempts to physically obstruct an officer or inflict physical harm on the officer. Despite the fact that interfering with a probation officer in the performance of his or her official duties is in itself a crime, federal probation officers lack the authority to correct or restrain a physically interfering third party. In fact, a probation officer's only course of action is to retreat from the situation. This not only exposes these officers to a heightened risk of harm, as they are not permitted to subdue the assailant, it also allows the probationer to conceal evidence that he has violated terms of his probation or supervised release or any other criminal activity. H.R. 1039 is a reasonable and responsible remedy to this very real problem. This bill, which has the support of the Administrative Office of the U.S. Courts, will protect probation officers and enhance their ability to do their job by giving them authority to arrest a third party who forcibly interferes with an officer's performance of his or her official duties. This bill would not give federal probation officers general arrest authority. Rather, as noted, it grants them the very limited authority to arrest a third party who is interfering with the duties of the officer. I urge my colleagues to support this common sense measure to ensure that these dedicated men and women have the necessary authorities to undertake their duties safely and effectively. And probation officers care very deeply about this proposed legislation. And I want to acknowledge that two of them are present here in the hearing room. Former U.S. probation officer in Colorado and Northern District of Texas, Carrie Kent, and Lisa Berry, a current U.S. probation officer in the Eastern District of Missouri. Ladies, welcome. Thank you for your past and present service, and we're going to try to fix this problem for you. And the chair is now pleased to recognize the ranking member for his opening statement.
Thank you, Mr. Chairman. I am sorry to report that I must, with some reluctance, oppose this bill for several very important reasons. To begin with, I believe the changes the bill would make to current law would significantly alter the role of federal probation officers and invite abuse in the application of the proposed expanded authority. Federal probation officers perform a critical service in interacting with and managing their supervisees. They have a central role in seeking to achieve the important goals of supervision. That is, to rehabilitate the defendant, to protect society from further criminal conduct by the defendant, and to protect the rights of the victims. Although they do have ability to arrest the supervisee under certain circumscribed conditions, I think it best that probation officers not take on the role of police officers and instead focus on their roles of working in a constructive manner with supervisees to maximize the chances of adherence to the conditions of supervision. We certainly do not want probation officers to be threatened or assaulted while performing their duties, nor do we want anyone to obstruct the performance of those duties. And that's why Congress enacted Section 111 of Title 18, which prohibits such behavior. If violated, these crimes should be investigated and charges brought when or where appropriate. In fact, probation officers have long relied on trained law enforcement officers to provide support during searches, and I believe that that is still the best course to continue. Section 111, however, itself presents serious issues about the vagueness of some of its terms that define violations, such as interferes or opposes. This exacerbates my concerns about allowing probation officers to arrest individuals whom they are not supervising for violations of this section. Making such determinations on vague terms like those mentioned invites abuse. Indeed, we're told by proponents of the bill that federal probation officers plan to use lesser included authority to detain violators instead of bringing them in for charges after an arrest. To me, this is an invitation for abuse and indicates the statute may be used at times when not even necessary. And at a time when we need to do more to de-escalate circumstances involving confrontation between law enforcement and citizens, I'm concerned that introducing this authority will only lead to more confrontation and may have the opposite effect that was intended. This is all the more troubling because of constitutional concerns regarding such detentions. The Federal Public Defenders of New York detail these concerns in a letter to us opposing this bill. And as the letter states, and I quote, "The Fourth Amendment does not permit probation officers to exercise this lesser included power. Under an exception to the Fourth Amendment's probable cause requirement, police officers, when executing a search warrant, are permitted to temporarily restrain third parties absent probable cause for arrest, including by using handcuffs. In holding such detentions to be reasonable, the Supreme Court emphasized the fact, and I quote again, of prime importance that the search was authorized by a neutral magistrate's finding of probable cause to search the premises. So in the circumstances contemplated by this bill, the probation officers would have the right to be on the premises, but their underlying authority to detain individuals, not based on a probable cause warrant, would not rise to the level required under the Constitution. Furthermore, the bill would put the federal courts in the position of ruling on the constitutionality of the arrests of probation officers who are themselves agents of the federal courts. All of these arguments are detailed in the very thoughtful, and I say prudential analysis by the federal public defenders. And so I ask that that letter be included in the record, Mr. Chairman.
Without objection, it will be made a part of the record.
Thank you. As the defenders state, the bill represents a retreat from the current constructive role of probation officers in reintegrating offenders into society. If probation officers assume the role of police directing and restraining or arresting family and friends, progress in individual cases and the system as a whole would be undermined. And I would add, seriously undermined. The American Civil Liberties Union and the Leadership Council for Civil and Human Rights have also sent letters opposing this bill and outlining many of the same concern, and I ask unanimous consent that their letters be inserted also into the record.
Without objection, they will be made a part of the record.
Thank you, and so I urge the members of the committee to join me in opposing this well-intentioned but nevertheless harmful bill.
Would the gentleman yield?
Thank you. Yes, of course.
I thank the gentleman for yielding, and I appreciate the concerns he's raised. However, I would point out that a probation officer already, under current law, has the authority to arrest a probationer or an offender on supervised relief that the probation officer has reason to believe has committed a violation of their probation or release. However, there are occasions when a probation officer is meeting with the probationer that they get attacked by people who are friends or family members or other associates of the individual. And they have to have the ability to take an affirmative step to protect themselves rather than simply retreating. Otherwise, you'd have to have law enforcement officers present in many, many circumstances where you're simply meeting with your probation officer and you're not able to anticipate that these events might occur. So that's why I think that this bill, which is bipartisan, has the support of Democrats in the House as well as Republicans, has a lot of merit to simply help to deal with problematic circumstances. It does not give them general arrest authority, and for that reason, I must disagree with my good friend and urge support for the legislation.
Mr. Chairman,
For purpose of the gentleman from Georgia, seek recognition.
move to
Oh,
strike.
actually, it's still the gentleman's time, even though we're well past.
Thank you very much. I just wanted to add to the fact that I know the chairman's well-intentioned, but we've not had any problem that I know of with where there is a need or a necessity for adding law enforcement, that has occurred, and I believe that this is not necessary at all, not at all. And I thank the gentleman, and I yield back.
Thank you very much, and without objection, a letter from the ALUC will be submitted for the record.
ACLU.
No, this is a letter that we have in support of the legislation that would recount instances that justify this legislation. For purpose of the gentleman from Georgia, seek recognition.
Move to strike the last
Gentleman
word.
is recognized for 5 minutes.
Mr. Chairman, I thank you, and I'm afraid that this legislation is a solution in search of a problem. I've not heard of the problem that would justify this drastic approach, which is to give law enforcement credentials to a probation officer. Probation officers are not trained to be law enforcement officers. They're trained to be probation officers. And most of the time, probationees or supervisees come to the office of the probation officer. That's the way it works most of the time. Sometimes probation officers go to a supervisee's home or job just to check to see, to ensure that they're doing what they're supposed to do. They're at home during a curfew, or they are working, they're supposed to be working. They may go on site, and usually when they go on site, they go by themselves, and they generally exercise caution not to go places where there would be a security threat to them. But if you give them arrest powers and then send them into situations where they may feel threatened, and this may not be a justifiable threat. They just simply are not used to going into neighborhoods, let's say, where African Americans live. They're not used to being by themselves, going into that setting. And so they're naturally apprehensive, they are frightened, they are on alert, they're on edge. And you put that with an overzealousness streak that may be in the mind of that particular probation officer, you're setting up a situation where probation officer goes in Rambo style and decides to lock everybody up who has a harsh word to say to that officer, who may be telling everybody to get back and don't do this and don't do that, speaking in disrespectful terms or a tone of voice to someone who may be around a supervisee, and then decides with the power that we have given them with the passage of this legislation to just go in and lock that person up just out of vindictiveness. And so what it does is puts innocent third parties who are minding their own business, but they happen to be around when a supervisee is confronted by a renegade probation officer who's having a bad day, and then we get a lot of people locked up. This legislation, as I say, is a solution in search of a problem. There's a lot of unintended consequences that could be opened up as a result of passage of this legislation. And quite frankly, the people who are going to be adversely impacted by this legislation happen to be people of color, because those are the people who find themselves on probation in a overrepresentative way in this society. And so therefore, I ask my colleagues to consider the fact that there are other options for a probation officer who feels that they have been obstructed in an unlawful way. They can either call the police can then decide whether or not to arrest a innocent third party, or they can go to a magistrate and swear out a warrant for someone's arrest, just like a police officer who didn't have probable cause or a reasonable suspicion could do as well. And so I ask my colleagues to vote no on this bill. And with that, I yield back.
Would, for purpose of the gentleman from Ohio seek recognition?
Excuse me, Mr. Chairman, I seek recognition to yield time to the chairman.
The chair thanks the gentleman for yielding. I just want to make a couple of points in response to the comments made by the gentleman from Georgia. First of all, probation officers are law enforcement officers. They are not police officers, which some erroneously use interchangeably, but they are indeed law enforcement officers, and it is a crime to interfere with them, as per 18 United States Code, Section 111. And it is really, I don't think it's really so radical to suggest that federal law enforcement officers, which is what probation officers are, should be able to arrest someone who commits a federal crime by interfering with the probation officer's official duties. And should other law enforcement agencies really bear the burden of having to escort federal probation officers on searches or even home visits? And secondly, this is not a general arrest authority. So it's not just somebody hanging around that they say, well, I'm going to arrest you for this or that or the other thing. The authority would be permitted, they would not be permitted under 1039 merely to claim interference and arrest any third party, but rather would be required to establish probable cause to believe that the person has forcibly assaulted, resisted, opposed, impeded, intimidated, or interfered with the probation officer or a fellow probation officer. That's what you'd have to have before you could arrest somebody. So this is a narrow protection for probation officers that I think is important to enable them to do their job and do their job properly, and not something that is directed at any community or any broadening of arrest authority for people involved. For purpose, the gentleman from Rhode Island seek recognition.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, I actually toyed with the notion of offering an amendment to change this to the Probation Officer Endangerment Act of 2017, because I think what this legislation does is really present tremendous dangers to probation officers, and I think in every way this is a colossally bad idea. First, it's a clearly unconstitutional delegation of responsibility from the executive branch to the judicial branch. Probation officers are employed by the judicial branch to serve as administrative units of the district court and Article III court. The enforcement of the criminal law is the quintessentially law enforcement function that rests with the executive branch. And the difference in the example that the chairman used about a probationer being subject to arrest, well, that person is under the supervision of the court already. That is quite different than giving arrest powers to a probation officer. So you have a very serious separation of powers question because you are delegating to the administrative unit of the district court executive functions. And I'm going to just quote from the letter from the Public Defenders of New York. This is not only a formalistic concern. A probation officer who has arrested a private citizen for impeding the probation officer in his duties would naturally have a direct personal interest in both the legality of the arrest and the outcome of any resulting criminal case. The court, in turn, is the probation officer's employer. So when ruling on a challenge to the constitutionality of an arrest by a probation officer, the court would thus review the actions of its own agent, who is also the interested arresting officer and alleged victim to an offense. You can see why this presents very serious conflicts and a clear violation of the separation of powers. The second thing is it includes a Fourth Amendment requirement that is waived really by this. As you know, as all the members of this committee know, the Fourth Amendment requires a warrant before someone can be arrested, subject to only a few very specifically established and well-delineated exceptions. So you also have very serious Fourth Amendment concerns when you're giving arrest authority to a probation officer in the absence of a warrant, which is a part of our Constitution. So you have two very serious, I would suggest, constitutional problems with this statute. The second point is the bill is unnecessary. As my colleagues have said, it's a solution in search of a problem. There is, in fact, not a single instance that was cited in the U.S. Probation Service and Seizure reports or in the Judicial Conference letters in which a probation officer requested law enforcement in advance or called for assistance from the scene where law enforcement declined or failed to show up. In fact, as the chairman said, the only course isn't retreat. The course is contact law enforcement to, in fact, do what is necessary to arrest an individual. And so the notion that there is a system which is not currently working is simply not true. There's no evidence whatsoever that probation officers need the ability to arrest third parties without a warrant to address some serious problem. It's really a solution in search of a problem that will create, I would suggest, many more problems. The third issue is probation officers are not trained police officers. And so giving them police powers in the absence of training would really put probation officers in danger. Probation officers typically get a 6-week orientation program. It is very different from police training. I was the public safety commissioner of the city that I was mayor of. I know what police academies do. They generally are 16 to 21 weeks of classroom and field instruction. They provide all kinds of training which probation officers do not have that show them how to effect safely an arrest of another individual. So I think while this may be well-intentioned, it is fraught with practical problems, with constitutional shortcomings, and addresses a problem that just doesn't exist. We will be responsible for putting probationers in a position of being the only people in America who can arrest someone without a warrant, without being properly trained to execute that arrest, and then go into a courtroom and testify in front of their employer about the legality of that arrest. That is a recipe for disaster.
Would the gentleman yield?
I'd be delighted.
I'd like to address several of your points. First of all, Congress authorized the judicial branch to have law enforcement authority when it established the Supreme Court of the United States Police right across the street from this building. Secondly, the authority that is granted in this bill is very common among state and local probation and parole officers. So it's not new. It's done already in many state and local governments across the country. Finally, federal probation officers currently, right now, receive extensive, ongoing, nationally standardized training regarding firearms, regarding the use of force, and regarding search and seizure protocols. So the gentleman is simply not correct.
Well,
when he asserts,
Mr. Chairman, with all due respect, we're claiming my time.
Reclaim your time.
Yeah, we're claiming my time. Mr. Chairman, whether or not states authorize probation officers to arrest third parties without a warrant is, while it's interesting, it's unconstitutional. We have a warrant requirement in our Constitution. Secondly, police officers are trained differently than probation officers. So I think we have a responsibility to honor the provisions of our Constitution. The ability of probation officers to arrest probationers is predicated on the fact that they are being supervised by the court. That's not what this is. This is a third party. This is someone who is not subject to the supervision of the court, and we're allowing a probation officer without training, without a warrant, to take them into custody. It's a recipe for disaster. I urge my colleagues to vote now, and I yield back.
For purposes of the gentleman from Okay, what purpose does the gentleman from Texas take recognition?
Mr. Chairman, thank you very much. And there's one thing that we compliment you for is your patience for the vigorous arguments that we believe are so meritorious. I thank Mr. Cicilline, and I'd like to follow his theme by making this point. This bill is so racked with constitutional violations, I don't know where it will go. First of all, we have been unified on this committee on our support of federal law enforcement officers and really our support of best practices for law enforcement across America. And that means that we try to encourage and applaud, but also provide resources. In the appropriations that we just passed, the Cops on the Beat program was enhanced by Democrats, and I hope Republicans coming together. We plussed up Cops on the Beat monies. I want my constituents back home to know that. But the probation officer structure is one where some carry guns, and in some jurisdictions they do not carry guns. Also, this particular legislation never had a hearing. And what I think is important that I want to make note of is that probation has a unique framework. The goal of probation is rehabilitative in nature and not punitive, as exhibited in the punishment created under this bill. The rehabilitation sought thus creates a unique relationship between a probation officer and the supervisee, which necessitates trust on both ends. They may know the family members, and over the years, they may have known how to deal with the family members. Now you entrust them with an unconstitutional right under statutory law to violate the Fourth Amendment, where they have the right to arrest or detain without a warrant and without documented probable cause that a judge has indicated or that can be documented. So take, for example, you have in the real world, I see this all the time. Maybe some people don't have this in their districts. I do. This could be the mother of a son on probation is arrested for denying a probation officer access to her private space like her bedroom, or because she is chattering up a storm because of the argument about he didn't do it or he was home or whatever. That calls for an assessment, a comeback, another process. It doesn't call for arresting the mother, detaining the mother. You are racked with no constitutional basis for doing so. So I'd ask my colleagues if they think of anything, and we know what rights probation officers have. They have it based upon forcibly assaulted, resisted, opposed, impeded, intimidated, or interfered with a probation officer or a fellow probation officer. Now you're going into the third party and you have no basis, no warrant, no facts, no hearing. Now let me conclude and ask, as I said, for opposition to this particular bill. Then, Mr. Chairman, again, Mr. Ranking Member, we have worked collaboratively together. As we speak, Director Comey is now testifying in the Senate, and next week, former Deputy Attorney General Sally Yates is testifying regarding the Russian connection, the actions of this administration, the connection to Russia, General Flynn. I am asking this committee, we cannot remain silent. It is a deafening silence. We have had no hearings on the question of the Russian collusion of this administration, and we are the first line of offense on articles of impeachment. That may be relevant, it may not be. But certainly hearings are relevant about potential criminal activity with individuals in any administration. And I have sat here long enough to watch the allegations and the charges and impeachment proceedings against one president at least, and my colleague, the dean, has seen more than that. And I sat here through the Waco long-ended hearings of that tragic incident where enormous loss of life. There is no reason why, when this blatant, obvious potential of wrongdoing alleged cannot be and should not be investigated by this particular committee, and certainly committees dealing with crime and constitution. So I
The
hope,
gentlelady yield.
I'll be happy to yield.
I want to commend you. You've raised two, in my view, separate but very important issues, and I support your reasoning and your insistence that this committee do its responsibility in conducting hearings. I think for us not to do that would be unthinkable, and I congratulate the lady on her comments.
The time of the gentlewoman has expired, but I would be happy to extend additional time to the gentlewoman without objection if she would yield to me on the last point that she just raised.
I'd be happy to accept the time and to yield to the gentleman,
thank
both gentlemen.
I thank the gentlewoman for yielding. I just want to say to her that this committee has inquired of the Justice Department to be sure that they are doing their job and properly investigating the matter that the gentlewoman raised. And I would point out to her that in the last Congress, there was great concern regarding whether or not the Federal Bureau of Investigation was properly investigating alleged charges against the presidential candidate of her party in that election. And I would point out to her that this committee did not hold any hearings on that issue until after the Attorney General of the United States met on a plane with the husband of the former Secretary of State and presidential candidate, and after the FBI director announced that he did not think that charges should be brought against Mrs. Clinton. It was only then that this committee acted. So we have both acted responsibly to be assured that there is an ongoing investigation, because both the chairman and the ranking member have been so advised by the director of the Federal Bureau of Investigation that such an investigation is being conducted. And we have not sought to interfere with that investigation by holding hearings, just as we did not seek to interfere with the investigation regarding Mrs. Clinton by holding hearings until after the FBI announced their position with regard to that investigation, which, as you know, was very controversial throughout the remainder of that presidential election. So I appreciate the gentlewoman's concern about that issue. We are watching the issue closely, but we think we are acting properly in our oversight responsibility, not of the State Department, not of the White House, but of the Justice Department, to be assured that the director of the FBI is indeed conducting the investigation that you seek to have conducted. And so I thank the gentlewoman for raising.
Gentleman, yield for just a moment. Just to appreciate just a brief appreciation for the chairman on that commentary. That was an election. As you well know, the FBI director did not restrain himself from casting great doubt and injuring the campaign process, even though he knew that he was investigating the Russian collusion as of July 2016, but he decided to publicly announce that of Mrs. Clinton. But the point is that was an election. Now we talk about the President of the United States. You had no basis to impeach either candidate. We do have a basis of impeaching the President of the United States, and I don't think that we should be long in relying upon the Justice Department has an Attorney General that's recused himself. The new Deputy Attorney General just walked through the door. Mr. Chairman, I think we are brilliant-minded persons here on this committee with you and the ranking member. I think we need to begin our own hearings, exploratory hearings.
The gentlewoman
And
does not even have before this committee any such basis for doing that, and the committee has acted responsibly in reviewing the concerns raised about whether or not the department has indeed been and is now conducting an investigation, and that's the...
Would the gentlelady yield momentarily?
I'd be happy to yield.
I would like to propose that the chairman and myself begin to meet on this as opposed to trying to resolve it under these circumstances with a completely different issue in front of us.
First
Would
of
the
all,
chairman be
if the gentleman would yield,
Sure.
Let me just say that, as I stated, when there is allegations of criminal misconduct, those are handled by investigations by the Department of Justice, as was handled in the case with Mrs. Clinton, and that because of allegations made now, that is being handled that way as well. But there is no basis for this committee to begin to meet and discuss anything other than making sure the Department of Justice is doing its job, and that is what they are doing.
But I'm suggesting that the chairman and I have discussions. We don't have to have any standards to have
I don't see,
discussions.
I don't see any need to, I mean, you and I can always talk, but I don't see any need to have any formalized requests for such discussions when there is nothing before this committee that would suggest that would be appropriate. And
Well,
I know,
I do.
well, I appreciate the gentleman's interest in that. This matter is being investigated by other committees that have jurisdiction over the underlying facts, and it is being investigated by the Department of Justice, and you and I have both been assured of that.
Well, that's all right, but I still want to talk with the chairman of this committee. I mean, I don't see where that's all precluded by all of these other inquiries that are going on around us, sir.
I appreciate the gentleman's position. Are there any amendments to H.R. 1039?
I have excuse me, I'm sorry. Mr. Chairman, I have a document I'd like to put into the record.
Without objection, it will be made a part of the record.
ACLU letter, thank you.
A reporting quorum being present, the question is on the motion to report the bill H.R. 1039 favorably to the House. Those in favor respond by saying aye. Those opposed, no.
No.
Being the chair, the ayes have it, and the bill is ordered reported.
Chairman, I'd
A
like a
recorded
record
vote is
vote.
requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Chaffetz? Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes yes. Mr. Collins? Mr. DeSantis? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Mr. Gates? Mr. Gates votes yes. Mr. Johnson of Louisiana? Mr. Johnson votes yes. Mr. Biggs? Mr. Biggs votes yes. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler? Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Raskin? Ms. Jayapal? Mr. Schneider? Mr. Schneider votes no.
The gentleman from California.
Mr. Issa votes yes.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes yes.
Gentleman from Texas, Mr. Poe.
Mr. Poe votes yes.
We're going to have to keep this open if you want to let your members know that we're too short. Yeah, I think we're gonna do a little Facebook thing. Check with Catherine. Do you want to do that right now? Yeah, we'll do it as soon as we get this vote wrapped up. The gentleman from Ohio, Mr. Shabbat. Gentleman from Florida.
Mr. Deutsch votes no.
You're recorded as no. Gentleman from New York? No. Has every member voted who wishes to vote? The clerk will report.
Mr. Chairman, 15 members voted aye, 7 members voted no.
The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. This concludes our business for today. Thanks to all the members for attending. The markup is adjourned.